Rashida's here too.
Meeting.
Was Nathan down in the office?
He said he'd print them.
Oh, okay.
Ryan, how you doing? Good, very good.
You already know. That picture is something else. I gotta post it. But what you call has another one. I'm gonna send it to you guys.
Who's that?
That's Marie. She took it.
Oh,
The photographer.
the actual, yeah.
Yeah. Good morning, Boo.
Thanks, Nathan.
Some more of these to bring.
Packed house today.
Hi, how are you?
The pricing. So loud. Yeah. It's the fines and penalty schedule. I can get that, but it's not, that part's not being amended. Yeah, okay. Oh, I'll get it.
Yeah.
I need a new pair of glasses.
Yeah, you know, I'm in charge of acting. I said, I can't get this.
Exactly. I need some
ask me to
stronger
read
ones.
something. I'd have been there like,
All right, 12 noon, 1 o'clock. All right, good afternoon. I'm going to call this meeting into session. We are meeting this morning. This is the Committee of Housing and Homelessness meeting for the Bureau of Administration Adjudication, to authorize the addition of unpaid fines and penalties to, what is it, to?
Roll over to the taxes.
Okay, to be put onto taxes. All right, with me I have Counselor Hogan, Counselor Nave, Counselor Peniagua, Counselor Caldwell, Counselor Williams, and myself, Counselor Jones-Rouser. And to start, we can just go to, Leah, are you Commissioner?
Director and
Director.
Chief Administrative Law Judge.
Okay,
And I've
so-
got my Deputy Director, Lee Terry.
All right, thank you. So you
Yeah.
can just give us a little synopsis or background of the department for those watching, so that we'll have a little background information before you go into the amendment.
Sure. So the BAA was enacted locally here in Syracuse in 2018. It was enabled as a mechanism to expedite the process for non-compliant property code violations. Prior to that, the only mechanism was for the law department to file in local housing courts, which was a lengthy process with limited outcomes. The BAA's authority is just for issuing civil fines and penalties, and nothing more than that. Since the BAA started, we've struggled with a collection mechanism, which is reflected every year when you're presented with a budget and you're looking at the fines and penalties that are issued versus the revenue collected. And just to back it all the way up, when codes issues a code violation, they issue a notice of violation for 1 or 20 code violations. Those notices have a comply by date. If the property owner fails to comply within that time frame that codes has given them, then the code inspector issues a legal warning letter. That legal warning letter is going to give information that if they still don't comply, the case could be referred to the law department through the old mechanism or ticketed and fined through the BAA. At that point, if the property owner still doesn't respond, that's when codes can refer the case to the BAA, and the tickets have an associated fine for each violation. And Counselor, that's the schedule that I think you were asking for. That's in the SPCC. That they range from $50 for periodic inspection first round violation up to $1,200 for a second round zoning violation. Most of them, a general property maintenance is $150 for a first round. Blight, that would be mostly, trash and debris, overgrown grass, some exterior violations, those start at $75. When you get that ticket, you have 30 days to respond. You can either pay the ticket in the full amount due. Payment is an admission of guilt. You can request a hearing, or you can default. Right now, about 50% of property owners default, meaning they don't enter a plea. 25 to 30% request a hearing, and the rest pay. What we've found is those that engage in the process by requesting a hearing or paying are far more likely to comply with the violation within 30 days of that hearing. And I believe recent analysis that we've done with MBD is that where owners request a hearing, 52% resolve code violation within 30 days of the hearing decision. And of those, more than half were addressed before the hearing occurred, right? People get the ticket, and if they're going to engage in the process, they want to show up at the hearing showing, hey, I've done everything I needed to do with codes.
Would you mind, so 50% default, and then roughly 25 to hearing, 25 payment?
It's like 25 to 30% hearing,
Yeah.
and then probably it's more like 50 to 60% default, and so then 20% pay.
Okay.
Yeah.
Got it.
And so what we've been trying to do is come up with a collection mechanism, right? The local law that enables the BAA gives us the ability to file judgments in the local courts. We explored that option for the past few years. That has prohibitive cost and capacity issues, right? Each filing, we have to pay the $51 cost to file that in city court. And it takes a lot of internal capacity to do that.
Before you go too far
Sure.
into that, I just wanted to go back to the process first. So it's about 15 to 20 days from the date that the code or zoning gives a fine, and they are
No, that's the comply by date.
not for the BAA, for codes.
They're not giving a fine. They're giving the notice of violation has a
Yes, I'm
comply
sorry.
by
That's
date,
what I mean.
which could be 24 hours to 30 days for a
Okay.
periodic inspection.
All right,
And
and
then
so-
if you don't respond,
It comes to
then
you
they're
guys.
sending a legal warning letter.
Yes.
So it's a second notice, again, outlining all of the due process that the property owner has, including At that point, they could request a hearing with codes if they're contesting the validity of the underlying violation, or it's saying if you don't comply, then codes is going to refer this legally either to the law department through the local courts or fine you and send it to the BAA.
So in total, how many days is an average before it gets to you?
I think that depends on the type of violation, right? Some of the violations, like I said, it's 24 hours, some are 30 days. I know Ryan Shield, the Director of Code Enforcement, is here. I think it's hard because they're all different types of violations, right, Ryan?
I just want an average.
Yep. Yeah, I mean, we'd like to, all inspectors to do, refer cases within 30 days past the comply by date. So essentially that'd be 45 days after, it was initially cited. We let inspectors use discretion based on, sometimes owners have, valid reasons on the delay or something. So obviously we want to, let them have that discretion, but, essentially we want everything referred within the 30 days past the comply by date.
So can you give me an example, something like 24 hours that would go to you?
That if they would come to me, sometimes we see if they declare something unfit, and then it's got the unfit with all of the corresponding violations and they don't comply. Within that time period, those might have the 24-hour warnings, and then they come, after it goes through, they miss the comply by date, they don't respond to the legal warning letter, and then the inspector refers it to the BAA. Usually with those, we see multiple violations, right? It's the majority of our cases, there's a number of violations, like the numbers so far through, January 22nd of 25, so this fiscal year so far, which is just a little over 7 months, there were 1,353 just complaints referred, and that totals 3,721 tickets, right? So codes goes by their overarching complaint. So you've got a property at 123 Allen Street, apartment 1 gets cited for an unfit. Well, it also has, interior peeling paint, mold in the bathroom, clogged tub, the refrigerator's broken. Each of those is a separate ticket with a separate fine that can be adjudicated. Somebody's entitled to a hearing on each of those individual violations. Most people request just an overarching hearing on all the violations, and if we have property owners requesting hearings on multiple complaints or multiple properties, we try our best to lump those through, which I think you see reflected in the weekly BAA calendar that's sent to all of you on the council.
Which is your backlog? How much of a backlog do you have on cases?
For tickets being issued,
Ticketing issues and when codes brings an issue, because there are times maybe codes will talk to the landlord, talk with the property owner, they have to be done within 2 weeks, 3 weeks, it hasn't been done, and then codes will talk to the property owner, and now we got more delays.
so again, when codes issues a ticket to us, they're still working the case, so the inspectors are still doing what they need to do.
Okay.
They've got their monthly check-ins for inspections on the case. They're working it, and that goes back to my initial, number there saying that 52% of property owners that request a hearing close out the violations within 30 days, right? Those are the ones engaging with the process. Once it's referred to the BAA, though, the property owner is dealing with 2 separate paths. They're dealing with the underlying code violation and correcting that with codes, and then they're dealing with the fine of the BAA ticket, and which they can request a hearing, pay, or if they do nothing, they default, and then a penalty is added.
Okay, so they get default, when they don't show up after 1 or 2 hearings, what happens then? They don't show up.
They don't show up, a penalty is added, and the Bureau issues a default decision in order, giving them another 30 days to request a stay of default. And it's not until after that point that we're asking for the local law and the corresponding ordinance to be amended to give us the local authority to roll those over into the taxes. Right now, the only collection mechanism that we have that's been viable, like I said, for cost and capacity reasons, is when somebody sells their property, right? They do a tax search. So they reach out to the city payment center. The city payment center reaches out to my team, and we give a list of any outstanding BAA fines and penalties, and those are included in the tax search information that that property owner receives, and those are usually paid at that time because nobody wants to pass off title. They're not judgments or liens, but they're outstanding fines and penalties owed to the city. We are asking that it be formalized so they're rolled onto the taxes just as we do with all other types of violations, cut and cleans, board ups, illegal set outs, water, anything that's not paid, that it gets rolled over.
My concern is that if codes is giving tickets and violations, and I've had a lot of violations that shouldn't have been violations, like grass cuts that they cut, and now people are going like, wait a minute, I cut my grass. Like, it's gonna be a lot of backtracking, and meanwhile, there's gonna be civil against them. So then we have to, it just seems like there's something missing in between still. Like,
I mean, we've been doing this for 6 years. I really respectfully disagree. I don't think anything's missing. I think the people that continue to get ticketed and that aren't complying with the violations and aren't responding to our fines and penalties, you know, there's got to be some back end.
I disagree with you because I know people
Yeah.
whose grass was cut.
Well,
that shouldn't
this
have been.
isn't for cut and cleans,
But
right?
I'm just
This
saying,
would
though,
just
there's
be
a,
for
what I'm saying is, as a
overgrowth.
common counselor,
Yeah.
that I feel there's something
Yeah.
missing in between that. So we're going straight at them legally. So we want to make sure that we want people to do right? We want safe homes. We
Yeah.
want to make sure it's clean. But we also want to make sure that we're meeting them every step, right?
Yeah.
There's 30 days. It's not just going straight at them
And
at a city.
this- yeah.
I'm still talking, excuse me. Straight at a city that is already poor. So all I'm saying is there one more step that possibly can go in here before we just start creating a fine, or we have to, go to civil? That's all I was asking. Is there another step that could be
Brian?
added?
Yeah, I just wanted to say, before it goes to BA, so when we issue a code violation on the legal notice, they have the right to request an administrative hearing to challenge the actual issuance of the code violation. So if they don't agree with that, they already have that chance when we send the initial violation letter. Obviously, when it goes to BA, obviously they have the right to request a hearing and challenge, the fines that way. So they do have a right to challenge the code violations in general and then the fines associated with it. So they do have two chances to do that.
So
Okay.
how about, and this is kind of where she's at, is there anywhere in the process that we consider an extension of this period of them fixing or constructing or, whatever, if they are actually working on
Yeah,
it
we
and they
do
can
have,
prove it?
Oh, excuse me. Yes, we do offer extensions. We have an extension letter which both the inspector, supervisor, and the property owner can sign and agree to a date. We also get verbal sometimes. I mean,
So
there's
what's the process, if I was the property owner, what do I need to do to get that extension?
You would request a letter from code enforcement, whether supervisor or the inspector. We can provide that letter. We come to an agreement on the date. It's reasonable. Yeah, and there's both parties would sign it with the date.
What is the process like? So for instance, I'm just using grass because I just knew I got a couple calls last summer. Where is it that you say, okay, no, this grass is too high, right? And then you say, oh, we're going to fine this property owner because this grass is too high. Is there something in the book? Is there you just do, what is the proper?
With what, the amount? I believe it's 10 inches. Yeah.
Inches?
Yeah.
Okay.
No,
Is it 8?
it's 8.
Yeah, 8. Yeah, I'm thinking of the New York State code, but the city code's 8, but.
Yeah.
Can I ask Leah or Ryan, I'm not sure, what is the ballpark value of the defaults each year?
So far this year, so again, through that January 22nd, this fiscal year, for total fines and penalties that have been issued, it's a little over 1 million.
Okay, so double that, 2 million, half that's about $1 million each year.
Yes, and collected in,
The default value, we're about halfway through the year, we're at $1 million in fines issued, double that and take half, we end up with a default value of roughly $1 million.
yeah.
So to me, I hear the concerns of my colleagues.
Yep.
And, I'm kind of differentiating between the process prior to issuing the default and then what has to happen afterwards.
Yeah.
And, Counselor Hogan, myself, we took part in a group that got together to talk about revenue enhancement. And I think about the opportunities to actually collect funds in the city, and we're limited.
Yes.
And, you know, here we have $1 million sitting on the table that we could potentially recoup, which is, again, different from the concerns that my counselors,
Sure.
you know, fellow counselors have shared for the fact. You know, I think that we need to give all the tools at our disposal to our, you know, financial team in the city to kind of right the ship, given our fiscal deficit. Can you, I know that the timeline has come up with some of my colleagues in terms of discussion, and, you know, why now? Why are we pushing so aggressively for it? Can you run through, you know, it would be a local law that would
Yes.
take a cycle or two, and then what do we have to do after that point in order to actually put a fee onto the taxes?
Sure. So before I get to that, I just want to jump back to Counselor Caldwell's, just to make sure it's like very clear, right? When it gets to the BAA, it's gone through their code process. And when we rolled this out, we really instituted that the inspectors need to communicate with the property owners, right? That's why we instituted that legal warning letter for the BAA. That's not required by law. We amended what the law department uses to include the BAA. And then when it gets to the BAA, they get the ticket, which we have to serve certified mail. So you're signing for it. So somebody's saying, hey, I had no idea. It's not a valid ticket. It would never get rolled over unless each of these steps in our process was hit. And we would be starting going forward. We're not going to retroactively do this on cases before the local law was amended.
So
you're
that's
getting-
where I kind of have a little bit of an issue, because I've dealt with two people currently who both was issued tickets at an earlier date, never seen the tickets. Well, actually, one never saw the tickets until they were supposedly issued in January. I mean, it's not your department, but they were issued in January, but they just received them in like December.
You're talking about the notice of violation with codes or the
Yes,
BAA
with
ticket?
codes, with codes. But the other person was with BAA. They received the certified mail with BAA, but they had never seen the original tickets. And so
They could contest, and that
they
would
did.
be their
They
defense.
did.
Yeah.
And I was going to tell them that you can contest it. And so they did have that additional time to figure that out. But that's maybe possibly the step that's missing. That's why I asked about, you know, the numbers of how many people are complying and everything, because somewhere tickets are getting lost. I don't know if it's because they're being mailed.
You're saying the code's notice of violation?
Yes.
Yeah.
Yeah.
And so that is always reflected. I think of a lot of the issues are property owners updating their address, and again, issues with LLCs and corporations, right? We're serving the address on file with the Secretary of State, and we're looking to shift personal service to them, again, because of the burden for certified mail, right? We've got a couple of local LLCs who just refuse the certified mailing because they know it's from us, right? So we can legally, we can personally serve the Secretary of State, and then they have it. But those are all defenses. If you get a BAA ticket and your defense is, I never got all of those, here's my address, and I updated it, and codes knew that, then our judges are going to take that into consideration, right? So you've got the ticket that serves certified mail. You don't respond, then you're getting the default decision and order that's giving you that additional 30 days, letting you know you don't do anything, it'll be rolled over to the taxes or filed as a judgment and lien. And then I guess also property owners have the ability to appeal decisions. We do those panels quarterly. I don't want to get too into the weeds in the process, but just to bring it full circle to Counselor Williams' question, to get rollover under the taxes, right now, we could file those as judgments and liens in the local courts. We have done that in the past, so we have that ability under the law right now. There is also state law that enables us, RPTL 901, to roll over onto the taxes. Unfortunately, that law was drafted as if Syracuse had not opted out of a tax legislation for the entire state, right? like Buffalo. Buffalo opted in. So Buffalo passed their version of the tax rollover before we did, and then they copied and pasted it for Syracuse. It was an error on multiple parts. It was long before most of us were here in 2017, 2018. So the law team tried to utilize that rollover and was unable to because, again, we don't use that. We don't use a judicial foreclosure process. We have the tax foreclosure process that we're all familiar with. And because of that, we can't use that state legislation. We have worked with the state assembly to try and amend or repeal it. And I believe Assemblyman Magnarelli's office attempted to put forth the repeal both in the summer session and then in the past January session, and it didn't go anywhere, right? At this point, it becomes complicated. So we believe our best option now is to amend our local law to do essentially what we already have the ability to do through other mechanisms. But why would I spend $51 per complaint to file it locally and file it as a judgment and then transcript it as a lien on that real property waiting when we already have a mechanism in place through our tax rollover, again, because we don't follow a judicial tax foreclosure process. And like Councilor Williams saying, it would generate the revenue quicker. People are going to engage. People are going to comply, right? That's the goal, is compliance. My end goal has never been generating revenue. In fact, in prior budget years, I've pitched revenue funds and got laughed at because we don't have any revenue to be self-sustaining. But we engage with lots of municipalities across the state and country that are doing really cool and innovative things with their funds. I think step one is to become self-sufficient with our revenue. And step two, again, all of the data, and I've spent a lot of time working with MBD and other departments analyzing the data. I think it shows that the more you get people engaged, and you're gonna get them engaged when they see it on their tax bills, the more likely they are to fix the underlying violation.
I think step one is to protect our neighborhoods. I think
Yeah,
you're right
and
there.
that's what I
they're
think
trying to
gets
do.
there, yeah.
And I think we're getting lost in the weeds here.
Probably.
Because if say you're a slumlord,
Yeah,
you get fined and fined and fined and fined and fined, but you don't pay.
exactly.
Because you don't have to pay.
Yeah.
So you let the house deteriorate, it falls apart, you're still taking money out of the house from tenants, and then you only pay any kind of penalty because there's a lien on it. So what do you care? The house is falling apart. That's what, when this was first proposed years ago, that's what we were concerned with. We were concerned in protecting our neighborhoods because there were people that were, destabilizing the neighborhoods by just being slumlords. And we just had this thing about good cause eviction and everything else, and people kept alluding to slumlords, but we have inadequate vehicles to address this issue. And that's why this originally came about. Because the former codes director would say, how come these people keep on operating? They keep on operating because they don't have to pay nothing. Because we don't require anything, because the only thing we can put is a lien on their property.
Yeah.
And just quickly following up on that, the state level legislation was passed specifically with the express purpose that it would allow municipalities to dispossess property owners who were negligent on an ongoing and perennial basis, because they would be continually fined, and those unpaid taxes that were unpaid fines that were rolled onto the taxes could be used to seize the property. So they couldn't just hang on to it, collect rent, drain the municipality, and suck the lifeblood out of the community. So it's not overly onerous to somebody who's engaged, who's trying to maintain their property. However, if you are a ne'er-do-well who has no intention of acting right with regards to the community in which you own property, it's going to be onerous.
I mean, I have more than a few ne'er-do-wells on the near west side. I could name a few of them, and they just kill these neighborhoods.
Yeah.
Kill. And they don't ever have to pay anything, because we can't throw it on their taxes, so we can never get to the point of seizing the
Exactly,
property.
and they know, and the numbers also reflect that, right, we can issue subsequent rounds of tickets. So each subsequent round, the initial fine amount doubles. So for a failure to apply to rental registry, the first ticket is $50. The second ticket is $100. The third ticket is $200. The numbers show that as you get past the second and third level, fourth, fifth level tickets, the people are less likely to respond. Those initial percentages that I gave you for if somebody's defaulting, paying, or requesting a hearing, it's almost all defaults. The people aren't engaging, again, because they know there's really no point in engaging. And at that point, they probably are behind on many things, right? And it's just adding up. So I think that, yeah, the goal here is, and the numbers show, and over the past 6 years, the data shows that people that are engaging, even if it's requesting that hearing, saying, hey, I never got these things, or I mowed the lawn, they were wrong. It was under 8 inches. I have this contractor come and do it. Here's the proof. That's why this is an administrative process that it is unique, because Lee and I are wearing our director hats, but we're also wearing our administrative law judge hats, where every property owner is entitled to a fair and impartial hearing, where codes has to submit their evidence, just like the property owner has, and we're not weighing one more highly than the other. We're considering everything that's submitted as far as evidence and testimony. And Ryan can tell you there are plenty of times where we dismiss or reduce things that they don't agree with because they didn't meet their burden to prove the case.
Do you have a list of the most notorious houses in the city as far as that have got liens on them? Can you relay that to the council? I mean, I'm talking about these houses that we keep on hammering with.
We haven't been filing the lien, so we just have our outstanding.
Because you can't, doesn't mean anything, right?
Yeah.
Okay.
So we have, we've got files and files and files for some property owners. Again, most of those are LLCs and corporations. Some are local.
Some are outside
some
the
are
city.
not. And it just gets challenging. But without some kind of back-end collection mechanism, like anything, I mean, equate it to parking, right? We get people to pay parking because we boot them, and they don't have a choice. It's not perfect. It's very inconvenient for people, and it makes people very upset. But that's how we generate that money, and that gets them to pay the tickets and hopefully learn how to park safely.
And also, maybe in this case, maybe fix the stuff.
Yeah,
in the
fix it.
houses.
Again, we just want people to
living in
fix.
squalor.
Yeah, that's the goal is compliance.
So technically, I'm sorry. Technically, our decision orders imposing penalties are liens on the properties by operation of law. If you look at our statute as it currently exists, but because it's not recorded in the county clerk's office, it doesn't lien the property the way most people would see it. So that's why we don't typically get paid voluntarily until there's a tax search done and the attorneys conducting the transaction see that there's unpaid fines that we say these could be arguably liens because our local legislation does already say that they're liens, but they otherwise will just sit there absent a transaction and remain unpaid, whereas if they were rolled onto the taxes, if they don't get paid, we will dispossess them of the property.
What in 2024, what has the court fees been? Or have you not gone to?
We have not filed anything.
Okay.
Yeah.
What about the certified mail process? What have you spent for that for 2024?
We don't keep track of that individually for the certified mailing. That gets rolled into the general budget. We use the communal mail machine within finance.
Okay. I wish that I could be like Counselor Hogan and think that this would just penalize a lot of, landlords or slum landlords or, LLCs. But unfortunately, probably 97% of the calls that I received last year was homeowner occupants complaining about fines that they received or what is it called?
Violation?
No, violations that they received. And I know that that's pre your department.
Yeah. So presumably you're connecting them with codes to try and get it rectified. Because I was going to say, I hear from Counselor Hogan a lot about cases, and I usually respond, but there's been very few cases that I've had any of you reach out about. And I think when you do reach out, we show we're willing to look at it and direct that property owner how to get to a hearing. And really, you can have a hearing at any point in the process. So there's different legal standards depending how far you are out, but we're always willing to give that information to somebody.
I think it's sort of apples and oranges what we're talking about, Counselor. You're talking about single-family houses or any kind of where there's one or two violations maybe. I'm talking about a way to address issues of chronic properties that destabilize the neighborhoods. And without something like this, I mean, I think you're talking about more or less codes issues, not about to get to the point of the BAA.
So that might be the route that we might need to look at, is the compounded amount. So if we have someone who has reached a certain level of fines in your department, is when we would start to administer this particular
To roll
law.
it over?
Yeah, not where someone has, I might have an elderly person in my neighborhood who, one, may not be able to read or comprehend the mail that's coming. They may not have any help in their home. And if they are seemingly ignoring because they're elderly, then that goes to the BAA, and then they're getting fines because they just really don't know.
They don't know, but they still own a property in the city of Syracuse
Yes.
and are responsible for maintaining that property.
Absolutely.
Right? You don't, just because you have, I had a 96-year-old neighbor next to me and the house was vacant for 2 years before someone bought and flipped it. Now it's still vacant because they haven't sold it. But that person and her family had an obligation to maintain it. And they're lowering my property value and that of my neighbors around me if they don't maintain it. So that's the mechanism, that if you're competent enough to purchase a house, and it's going
If I'm
through.
competent at 20 and 30 years old, and I'm 80 or 90 years old now, and I can barely even see.
Yeah.
That's what I'm trying to get you to
And
understand.
I understand that, but you still owned a house at some point. So what other mechanisms can we help? And if that person, we've got plenty of older people, plenty of new Americans that reach out. We have translation services for anything. We always request that. It's on all of our forms, how you can request interpreters, how you can request adjournments, that you're entitled to an attorney at your own cost. We're following all of the legal regulations and then providing some. And I think, we accept calls, emails, walk-ins. We've been working on the website to make sure everything's available there. You can contest right online now. And then we do the hearings in person, virtually, or on the papers, really trying to give everybody, in that, that has the ability to be able to contest at any point. And even if, let's say, it gets rolled onto the taxes, right? Because you've got the little old lady who didn't respond, and then presumably she's either not paying the taxes and it's going to go through a tax foreclosure anyways, or if she is because somebody's reviewing that bill with her, even at that point, she could still request a hearing, right? The local law allows for property owners to request it indefinitely. Again, the legal threshold that you have to meet goes up as time goes on, but you always have the ability for it to be reviewed by the Bureau. And in that case, just like we've done with some of the illegal set-outs, we may reverse and correct the tax roll. It's rare, but it's possible.
So if somebody reaches out to one of his counselors, I mean, we've had this discussion before, obviously, and you've been very receptive to that. I think it's like, call them and just sort of like, interject yourself into the process. Because there are people, like Counselor Jones-Rouser says, that might not be aware, but, you've got calls from me about this.
Ryan, can I get Ryan up there for a second? I haven't got you.
Actually, why you come up? We have a tax issue with a resident in the Sedgwick area. They're clearly over 80 years old, haven't paid their taxes in an extremely long time. I don't remember if they were over $100,000 or so, and no one can get to the people in the house. They don't answer the door. We had to send the police there to do a well check. Now, there's notes in the system of the condition of the property, but there's no code violations because that neighborhood is technically not a neighborhood where codes would think that they would be because it's more of a privileged area. And so that neighborhood may not be getting as many sightings or fees or violations as other neighborhoods. And that property absolutely needed to have some sightings, but it wasn't done. So that's on code side. I know that because everything's gonna come to you eventually.
Yeah, but what I'm saying is people have, before it comes to me, they have to work through Ryan and his side.
Yeah.
They have to work through you.
Yeah.
And
But what I'm saying is this particular family, this is in a well-to-do neighborhood.
Yeah.
We can't reach I don't know if we ended up finding them or not, but the people live there. They're there. They have no one to check on them. They're elderly. We had to send the police there. There are people with issues or conditions, that are beyond them.
Sure. But
No
that person
family.
probably shouldn't be a property owner, and they're probably, it sounds like, not even capable of caring for themselves at that point. I mean, I did foreclosure defense for almost 10 years, so I get the flip side, trust me. I really do. And I've told plenty of people that, now's not your time to be a property owner. You have to maintain. And I don't think this is just trying to get people to comply. We're talking about the back end mechanism to get those people to respond that don't respond.
I have a question for Ryan. Sure. Can you tell me again how many days? So it's 30 before it gets to BAA. How many days does it before it goes there?
So it'd be, calendar days would be 45
So-
or so. But again, like I said, we do give it extensions and we do have discretion on when to refer it. So, it'd be 15 days from the date we cite, issue the violation, that would be the comply by date. But then after those 15 days are up, we would like inspectors to do it within 30 days if we think the owner's being unresponsive or not working with us. During that whole 45 days, we're trying to engage with the owner and trying to get them to comply. We're trying to, speak with them, obviously. These fines are our last resort. It's not something we want to do. We even tell owners, hey, this is our last resort. We'd like to work with you. When we're referring this, we've either tried to engage with the owner or they haven't either been responsive with us or unfortunately haven't worked with us or haven't worked on the violations. Just to touch on some of the things that you stated about, maybe someone who's elderly or doesn't have a lot of money, we take each we understand there's going to be different situations. People are under different circumstances. We will take that into consideration. We also try to refer people to, work with home headquarters if they need, low interest loans and stuff like that. So that is certainly something we take into consideration quite often.
Let me ask you a question as far as staffing. How many people do you have in your department?
And codes overall, I believe there's...
No, that just works with you for violation. I know codes is big, but I've had people, because it's a process. So if you're giving people fine tickets, somebody has to come back, somebody has to check, somebody has to follow through, somebody has to call. You got 45 days for all this to happen. How many people do you have?
Inspectors or just staff total?
Inspectors, because inspectors are the one that have to come
Inspectors,
back.
there's approximately 30.
30 inspectors. In total, do you know how many is in it? I know Jake told us before.
Around 40 full staff with, we have 5 administrative aides and some support staff.
So it's like 40.
4 directors. Yeah, low to mid 40s. So,
What if it's a project, if someone comes and says like, I don't know, something happens on the outside and they can't get a contractor there and they're like, hey, we've made phone calls, we can't get a contractor here, what happens there?
yeah, I mean, that's certainly something we would take into consideration, given an extension for. Yeah, I mean, that's happened with multiple things in the exterior. Obviously, we'd ask for some type of proof. I mean,
we give you everybody extension here like 6, 5, 4. So I'm just curious, like seriously, like how long? Yeah, for a lot of projects, there's always extensions here.
Right.
How long does I know you take in consideration, but if honestly, like, what do you tell the people? What are you telling the constituents? Like, okay, if there is a contract issue, we know we have a major issue with contractors right now. Plumbers. I have somebody that's been waiting on a plumber literally for 45 days, just because they couldn't get the plumber to do the work. The work is extension right now, really extensive. What are you telling people?
I mean, we don't refer contractors just because I think there's a conflict of interest there. We can kind of, obviously teach them about Google or teach them about areas, online areas where you can find contractors on yourself. I just kind of stay away from the conflict.
Like on those type of projects. If people are like, listen, I got contractor coming, but are you giving them extension or is that automatically How does that work?
I mean, everything's situational, I would say. If someone comes with an invoice, say they hired a contractor, but they're 2 months backed up, say on the invoice they have a start date from 2 months from now. If we have proof of that, sure, it's something we work with, and maybe give it a longer one if we have proof. We do get people are untruthful with us as well quite a bit.
Absolutely.
Specifically, a lot of times with rental properties and LLCs, but we kind of have to gauge, truth versus people being untruthful, and what do we have proof of? It's just really situational, so it's hard to, kind of break it down. We don't have an exact process for certain things because there's just too many different scenarios that can occur.
But you do give a lot of formal extensions, like in the winter for exterior paint and exterior work like that before they come through.
Yeah, certainly. Like right now, I mean, it's hard for someone to paint or, do siding work or roof work. I mean, when you have 2 feet of snow. So we definitely understand that, and that's something we'd give an extension for.
I don't think there's anything more frustrating for a city councilor to sit in a neighborhood meeting and hear the same addresses time after time after time after time again. People saying, what about 309 North Geddes Street? What about 252 Lakeview Avenue? What is the same? Because and me trying to explain that we do everything we're supposed to do, but we just don't have something strong enough to make people comply.
And I know there's a lot of concern, as there should be, about the financial wherewithal of certain people to be able to afford these fines. But I would note, just by code enforcement choosing to pursue an uncorrected code violation before the Bureau of Administrative Adjudication versus a court of law, the fines are relatively nominal, because the fines alleged in a court of law are $100 per day per violation past its correction deadline, which amounts to $3,000 a month versus penalties ranging from $50 to $600. And those $600 ones are extremely rare. Those are, again, zoning violations.
Are they maxed out? Have we maxed out? Does the council have any authority? Or we had a discussion we had with Jake. We had a discussion about this a few weeks ago. About raising the fines.
Yeah, we've talked about that in conjunction with this pretty much at every budget hearing I've had for the past 6 years. It's something, kind of the second part of this was to evaluate and get a mechanism in place. And then we've convened like an internal task force, and then we were going to engage it externally with the council and other members of the public to see, what it was. But without a mechanism in place, it's hard to gauge how much those fines and penalties, if anything, should be raised, right? Because right now, even the nominal penalties and fines, because there's no, there are mechanisms, but we're not pursuing them for the reasons I've explained. It's hard to gauge, maybe these work. Maybe a $50 fine and a $50 penalty is enough to get someone's attention if it's going to roll onto the taxes.
Well, how much more can we raise the fines? Are we maxed out?
No. You can raise them.
Are we maxed out or are we not maxed out? Because we had a discussion with Jake and with Joe, had a meeting with them where I was told it was kind of maxed out. But the thing is also, with codes, sometimes they work closely with the landlord with their violations, and they don't do what they're supposed to do by the due date, and then they give it another extension too. So what I think some of these landlords do, they just keep on raising the ante, another week, and it's 2 months later, and then I have this constituent on Mary Street still got the same issues.
Sure, and I think that
right.
That's if you were talking to Joe, I'm assuming that was through city or state Supreme Court, the local housing court. They hold local housing calendars monthly. That's the $100 a day that Lee was talking about, and those are the cases. There's only a calendar in each of those courts once a month. And they tend to get adjourned, right? If the landlord or property owner is showing up, they get adjourned. And even though it has the potential, and the law department does get very large judgments against property owners, more than likely they settle out after it gets fixed some months later. Again, the BAA was enacted to be a quicker way to get people's attention with the quick civil fines and penalties through this adjudicative process, so that they fix the violations. But again, because there is no back-end collection mechanism, those that know how to work the system, work the system.
They do got to work the system, because some of them live out in the suburbs, and they're very wealthy.
Right. So at these levels, oh, go ahead.
Well, you can go.
Okay. At these levels, the idea would hopefully be that a well-meaning property owner, it would be sufficient to jolt them awake to do something, maybe even tell them they have a problem. If they've been living, you give the example of the older person, maybe a little cognitive issues. I really have a problem here. I need to do something, reevaluate, either get some help to address the problems with my property, maybe look at an alternative living arrangement if they're no longer self-sufficient. And we really do, once we issue a ticket, we do try and give people every opportunity to have their case heard. We have to follow the law, of course, but it is not difficult to respond to our tickets. We don't write it in a lot of legalese. It's really straightforward. You just have to fill out your information and sign the back of a notice violation ticket, and we'll schedule a hearing. And we allow them to be in person or virtual or on submission of the papers, whatever is most convenient for them, to give them every opportunity they could. So I think just in a broader sense, too, I think you have to evaluate, because all common councilors obviously want to do the best for their city and constituents that they can, and you have to look at the aggregate impact of these changes versus the potential for individual harm. And I think when you do that balancing, it favors passing this legislation.
You know, it just occurred, I'm sorry, Corey, this is just, it just occurs to me that maybe this would be something that the community ambassadors can be aware of, that we could use them to
The
lay some of the
community ambassadors
concerns.
haven't even started on the tax stuff that we wanted them to start on, so I'm
And
not
we see
sure
we
how-
see on a lot of cases, especially where there are landlord-tenant disputes, where maybe the tenant called in the violations, maybe there wasn't a retaliatory eviction, and now the tenant isn't letting the landlord in, that codes will bring the community ambassadors, and there will be information from the community ambassadors in the case from the inspector. And then a lot of times with hearings where there are issues like that, we will require the code inspector to appear and refer both parties to the community ambassador for that district to try and facilitate getting into the property and getting it rectified, and we'll do conditional dismissals. You have 30 days to work with codes. You're both sitting here, exchange contact, work with each other, get these violations corrected and closed.
And that's where I think there is another part missing, that codes or the BAA might be working with a community ambassador, but no one is contacting the district representative for that same property. So if I'm representing a district, I may know that person or have a better connection to find some means to get that addressed through a family member or, someone.
Yeah.
And so that's one thing that's missing. So
That
the
would, I think, be on the
collaboration
code
between the
side, because again,
departments.
we can provide that information and try and get the parties to work to each other, but we're still kind of independently fair and impartial. Just like if, I know Councilor Nave asked to come sit in on a hearing recently. We gave him the information, just like any of the public, anybody can come sit in. But you don't have an opportunity to testify. You can be there to observe. You could submit a written statement ahead of time. But, it's a fair and impartial hearing. So I think
I'm not talking about the hearing. I'm talking about.
No, I'm talking about with the ambassador and looping in the counselors. I'm saying I think that would be, if that was a part of it, it would be on code's end.
I think it's either way. What I'm saying is that if someone's not complying, let's just say they're not being reached.
Mm-hmm.
Maybe they haven't received the ticket. Maybe they threw the ticket out, whatever. They're not aware of the ticket. Let's just think that way. So that you've sent 2 notices to this address. No one has complied as of yet. Are you reaching out to the community ambassador then, or is the counselor?
Again, that part is all codes. It hasn't come to the BAA yet.
That before it should go to there.
Something's missing.
Something.
Right.
Go ahead.
Oh, I was going to say, so we, not only do we mail out the notice, but if we know there's a listed agent or property manager, we'll mail it to that address as well. But we also post the notice at the property. So every single time we issue violations, we mail the letter out, and then we also post it at the property. Obviously, a rental property, the owner's not going to be living there, but a home, home occupied or homeowner occupied, obviously, would receive that.
Are you
But
seeing?
that's codes, okay? That's codes. I'm saying once it's at the BAA, you're saying that you have a 25 to 30% comply rate, right? And then
I said that about 55% of people don't respond to the tickets.
okay, that's what I
Yeah.
wrote 55 I wrote
Yeah,
50
they
at
don't
first,
respond, but
then
again,
you said
they're
something
all,
else.
but it's a
Okay.
legal proceeding, that's what I'm saying.
Okay.
They're served certified mail, so before we move forward with a default, we have staff confirming that service has been perfected before we have a judge issue the default. So we know somebody at the address that we served, which we do legal research on the address, signed for it. And the people.
Excuse me,
Okay.
so when a ticket, BAA tickets issued?
Yeah.
They sign for it?
Yes, all of them.
Of the owners of the property?
And I had a constituent.
Somebody else signed it? What did you,
That-
what's the, okay, Counselor,
I had
tell me
a
what.
constituent who had like 3 or 4 dots where a signature was supposed to go. They said them or their wife never signed for it. So I don't know who to believe
How
on
many
that.
of
I
those
don't know
do-
if the mailman
I mean,
just dotted it
anybody could sign at the property of suitable age and discretion, right? So if you have multiple family members living at the property and they don't ever
There's
give you the
not.
mail,
It's just the 2 of them.
so.
So, I mean, they
in
got
those-
it.
in those
They got the
cases-
letter.
and did they
It was
dispute?
there, but they didn't sign for it.
Yeah.
That's all
Well,
I'm
I would say that's a rare case because we do review all of those individually to make sure we review up front. We don't just rely on the address that codes provides. We review and make sure that we have the best address we can find. We serve it certified mail and they have the opportunity to respond. So I think, we've had a lot of good discussion, but I think we're conflating the codes process with the BAA process, which
Absolutely.
has been around for 6 years. And I think if we want to continue to work on improving neighborhoods, which I've heard, repeatedly as a theme that the council and the administration is interested in, then this is the next logical step. And we have the authority on a state and local level. We're just asking to make it a little user-friendly for our office so that we're not spending thousands of dollars to file these, and that we get it in a way that will work for us. And I really think, nobody's perfect, right? There are cases that go through that things like that may happen or the underlying violation may be wrong. But I think that those are few and far between. I think the majority of people not responding are people that either we need to get them to fix the properties and hopefully this is the mechanism, or that it's going to get rolled onto the taxes and that will speed up the tax foreclosure process.
And I just harken back to the earlier point about we do roll over other charges now. So if people have challenges, with other matters as well, it doesn't make sense to me that you would be rolling over some things and not others, because if they're unable to respond to a BA ticket, they're unable to pay their water bill, they're unable to do different other things. And we're rolling over those charges now.
I have a question. So, just so I can understand the steps, right? All of the violations come from codes first, right?
Yes.
Right. So this is where we put another step here before it goes there. So then, if it happens, now the other question is this: are you working with the ambassadors at all?
Yes, we do.
You are working with the ambassadors.
Yes.
Okay. So the ambassadors are a part of the program.
You mentioned you had 30 inspectors, right?
Yeah, approximately.
Are they full-time or part-time?
No, they're full-time. I mean, people have different duties. We have 14 dedicated housing inspectors. They would do a lot of the rental registry, tenant complaint, exterior blight type stuff. Then we have some that are dedicated for more building permits and stuff like that.
Right. Also, okay, so when does it go to BA and when does it go to the courts?
That is kind of up to our discretion. Obviously, BA is a much quicker penalty, but it's, it probably just depends on the severity. Civil court takes a lot longer, but the penalties can be steeper. So depending on the situation, yeah, it's got to kind of be a group decision. Usually that's more of a decision with supervisors and stuff like that.
So there's no set thing that says, okay, no, this goes to the BAA because they're under the 45-day violation, or this goes to court. We don't have any kind of protocol that says these are higher fines, or this is a serious fine and needs to go that direction, or this needs to go that direction. How do we determine that? Would something like a rental registry issue not getting right and not done, would that ever go here?
It always goes here.
Yeah.
The ones that are going to law are far fewer, right? Let me give you the numbers. So through January 22nd, open complaints by codes, 3,544. Total that were referred to the BAA, 2,092. Total referred to law, 127. Cases that were referred to both BAA and law, maybe it went through the BAA once, didn't get a resolution, and then it went through law, were 48. So there is some overlap, but you can see how much smaller that law number is, again, because they're in housing court once a month, once for city court, once for state Supreme Court, and they're filing much larger petitions, personal service, and, it's a much more onerous process, both from the money side and the legal team's capacity. So the general guidance, and we've done multiple trainings with the inspectors. I think I did one with Meg Ryan from Law not that long ago. And that's why we amended that legal warning letter to include information and fine ranges for both the BAA and the law department as an extra step so that people know what they could potentially be fined.
So I have to miscorrect you. It doesn't always go there to you. It's courts. I know 2 different families that went to court.
No, I said there's 127 that have gone to law.
Right. You said no, that goes to far as rental registry. They always go to you?
Oh, maybe they might not always, now that we are not accepting their filing cases, failure to apply and obtain. So now they have to go through the courts based on recent litigation to get warrants to inspect. So that's the difference. If it's a failure to apply, those are almost always coming through us.
Yeah, I know 2 families, but the reason I just want to know if there's so if people know, so we could say, hey, there's a protocol, right? Mm-hmm. If you do this, you're going to go this way. If you do this, just to say, well, it's our discretion. This is where we find issues because we're not straightforward. We need to be straightforward, and we need to be, able to explain to people the process. Right now, it's like, well, you might go to court, you might go to BA, it depends. Seems like you guys are sort of making a judgment and not saying, because of this situation, oh, you're going to BAA. Yeah. If this situation, you're going to the courts, so that we have some kind of fine too. Right now, it's just like, well, you might go this direction. You might, and I know 2 families that went to court for rental registry, and the judge and the law department ended up getting thrown out by the judges because the rental registry thing has to still be cousin, aunt, uncle, cousin. You can't make a decision who's what, and we can't tell a person you're not their cousin. You know what I mean? A family member. So there's a couple of things that I think on the code side that we need to put in order so that we can explain to constituents, like, you're going that direction if you don't get it done, or you're going in that direction. So that's my biggest concern, because there's some things that needs to be fixed on this side before it goes to this side.
Yeah, well, we do have one protocol in place, and that's because, first of all, a high percentage of cases go to BAA. Obviously, it's, if we sent the amount of cases we had to Corp Counsel, they just don't have the capacity to take that on. But we do have a protocol where if we've referred the same case and same violations to BA on 3 different occasions, have had 3 different rounds of ticketing, then we'll refer it to law in that case, because, our feeling is that, they've already, BA is just, the BA fines are not getting it done, so we're going to have to take a different route. When we do law referrals, unfortunately, we do kind of have to make discretion depending on certain things, like Skyline, for instance. That's something that we went for receivership. Sometimes, if, say, there's a porch falling off the property that's at a rental property that's maybe going to cost $20,000 to repair, but, there's only 2 violations, that's only $300. Now, the penalties, if we took it to court, will be much steeper. If we, say even maybe we took it 1 round to BA, but they're still being unresponsive. It's a big safety issue. We don't think, hey, the next round might be $600 or whatever, may be it. But that's some owners know that they have to spend 20 grand on it, so they'll happily pay that $300. So, a situation like that, if we take it to civil court, sometimes it gets us compliance, sometimes better than BAA. So I think that's kind of where we decide. Which one to take to court.
Sometimes you need other departments, like 137 North Lowell Avenue, where we had to get the DPW and the police and everybody else in there to clean up over 2 tons of garbage.
And all of that takes capacity, right? So
Yeah.
if the law department's working on that or a skyline, that's pulling the attorneys from just the run of the mill. So that's why the inspectors in the law department has discretion over what cases to take. It doesn't harm anybody by pushing them through the BAA for that first or second time to try and get compliance. In fact, it's better for the property owner, right? Because then the fines, like everyone said, are much less. So they don't have to engage attorneys. You can represent yourself for the most part. We do see some attorneys, but because of those factors, it's hard to put it on. We've instituted, if it's serious health and safety, if it's repeat offenders, like with
What about,
Skyline.
like we have dumping on the near west
Yeah.
side. We have like severe destabilizing dumping like on Sabine Street, places like that. And those obviously have to go to housing court, I
Yeah.
imagine.
So for those, and I think that the inspectors, it's hard, for Ryan to say, well, they have discretion, but it's going through the supervisors, and I think they do a good job. If you look at the numbers from when we started, the numbers have gone up significantly, what they're referring through, which just ultimately means, more compliance on the back end, that more of the violations are getting corrected more timely.
Okay.
Is there, counselor, do you want to be, like maybe in your council district, you want to be aware of all the violations? Maybe so you can intercede like, you've done with the land bank properties, maybe?
Yeah, wherever I can assist.
Is that something you can do?
Absolutely. But for me, I'm more concerned, and I don't want to just say the little guy, but if it's like slum landlords per se that we know have continuously ignored things, like that's not a bigger concern for me. I'm talking about the person who is a homeowner occupant who may be struggling to pay their bills, who can't afford to take on extra fines and fees, or just may need help to understand the mail that they just received. Those are my concerns. So yeah, in that case, yes, I would like to be more aware of what's going on so that we can try to reach as many constituents as possible to try to help get things rectified. We have been working with the tax department to help in a larger capacity to get people to pay their taxes, and we have turned that around. I believe we've made a significant impact in that way.
Yeah, and we'd be happy. The whole idea with this would be you'd get your decision in order, right? Giving notice. Again, the ticket, the decision in order all have information. This could be rolled onto the taxes or filed as a judgment and lien. We already have that in there. And then we could add a third, notice. That wouldn't be a problem. And, counselors got copied. So every year before the tax rollover in May, you're getting notice at whatever point that these are up to be rolled over. These are the amounts. These are properties. Something similar to, the BAA calendar that you get. I think, from the BAA, we really have worked hard to provide anything that's been requested. That BAA calendar was something that was requested at the onset. We do that manually because we're using IPS that Codes is using, and there's not an easy way to pull that. So we have staff pull and compile and circulate that to counselors, the administration, and community partners so that people are aware of those cases. So we'd be happy to, add a third notice and list of everybody that hasn't responded to that default decision after 30 days and is now at risk of being rolled over. Again, nothing is going to happen for this tax rollover. We would need to, you would need to put this on the agenda, wait a session, table it, then vote on it. Then it would go to the state. And then once it's signed off on, we would start that, and it would be going forward for the tax rollover season in May of 2026.
Because a lot of times, as district councilor said, and for myself, we don't know what's going on. I get a call from a concern on Mary Street or on Beecher Street. I had one called my office last summer. He's 25,000 home. I didn't know nothing about this. And now I have to intervene. And now I got to work with the finance department, try to get him in a tax trust. So there's things we don't know.
Yeah.
And we want to get ahead of
I'd be happy
it.
to compile that,
Right.
you know,
We get ahead of
and
it.
circulate it with the weekly calendar.
To Councilor Caldwell's suggestion that codes, before it goes to the BAA, we would probably like to have you guys reach out to us before, once the 30 to 45 days or second or third notice have gone through on your end and there's no compliance, if there's a way that you could reach to whichever district counselor or any other counselors, I guess.
Send it to the counselors.
Yeah, I don't have a problem.
As a first
doing
step
outreach.
before it goes to the BAA. And
Maybe send a copy of the legal warning letter.
yeah.
Yeah,
With-
list of the names and addresses, because it could be something that one of the district counselors or the regular counselors, can say, oh, wait a minute, let me, this is the situation where can prevent that to happen. Because yes, we want housing right. Yes, it is a way of finances, but which the city is already, It's not the little people, it's some of the bigger organizations that we know, LLCs, that have multiple houses that are fine. It's not the small ones. So if there's people that we can try to get to, we would love to try to.
Yeah, like owner occupied and stuff like that.
Yeah, or somebody that might own one or two, homes that are, homeowners that are, trying to, create more money for their families, but need, a direct call. I've helped multiple people out with that. If we know, I think that next step would be, it would make me feel better before it goes to be.
Yeah, be happy to meet after this or, another time and discuss,
Yeah, we need to put that in
specifics and
legislation.
stuff. But
Yeah.
yeah, I mean, like we said, we're happy to try to work with people. That's what we always attempt to do before we get fined. So yeah, the more outreach is good with us.
Thank you. And my last question is, I know we gotta go. Do we have any? I know you like Rashida, stop. Do we have a list of court proceedings of how many we went to court and how many we won, like with
Oh, tax certiorari, or specifically in
for
these
like
guys' realm?
codes?
Oh,
Like
boy.
we go to.
That
No,
would be,
that's out of
that
my
would have
lane.
been Joe. Barry, Meg Ryan oversees the housing. Lee used to do it. Do you keep track of? They probably keep track of their cases, but again.
Yes.
Yeah.
They do. And, they do annual budget indicators and all that.
I would
so.
love to know the who, how many we're winning, how many we're not. And I'm also gonna put it out here for full disclosure that the rental registry, we have to fix the words in it. Because the words are, when you have on there relative, who's a cousin, who's aunt, you can't tell a person if that's their aunt or, if their mother remarried or their father remarried and now that's their cousin. So we have to, if we're gonna make this right and we're gonna make it right so people aren't going to court because we're saying that's not their family member, we have to put the wording in right so that it makes sense, so it can stop some of the court proceedings on what is considered family.
And you said you're doing everything by hand, so you guys don't have like a mapping system of like where high volumes of or regular fines are or violations are happening.
So again, the violations would be on a codes level. We have, I have every type of ticket issued, whether it's first round, second round, third round. I have all of that. The addresses could be populated. Usually MBD is helping me with that, those data sets, but I don't have specific locations. I don't know if Ryan, I know his inspectors are in, I don't know what you call them now, quadrant zones.
Yeah, I'd have to speak with the NBD team, the data team. I know they're in the open data portal. It shows what violations are open, who has a
On a
rental
map,
registry,
right,
who
if you
doesn't.
go in the open data
I don't know
portal.
if the BA data's on that. I don't think it is, but yeah, we can try to work with them to get that data.
Yeah, and I appreciate the meeting. I would just urge that it's going to take a while once you put this on the agenda. And I know, again, my budget hearing's coming up, and it's come up every single, time. Why is the revenue so low? I hope at least, we were able to show you today why it's so low and how we think, we can make the BAA self-sustaining, and hopefully that by doing that, it cleans up the neighborhoods even more.
You wanted to say something?
Later.
Can't make any bureau or any department within the city self-sufficient. Any revenue that's generated all has to go to the general fund, first of all.
Yeah.
Secondly, in terms of the Councilor Jones-Rouser asking about the code violations, et cetera, you just got an email last Thursday, I believe, from Michelle Zapansky. And I had worked with Jason Scharf on the open portal in terms of identifying each council district with code violations. I asked him specifically to put that in there so councilors could see it. Just like we did when I was on the council, getting the land bank identified by district.
Yes.
That information is there.
The look before you rent portal?
Yes.
Yeah.
Yes,
Okay.
that's there. As well as rental registry. Take a look at that. They just updated it on Wednesday or Thursday last week.
Yeah. So I guess with that is one route, but you will just have to kind of populate the address. I was looking for more or less like how the land banks look when you see the entire map. You see all the dots, and then you can hone in on it. Or you'll see a large cluster over here and nothing happening over here. So that's really what I was talking about, but we'll take a look at it. I have looked at it, actually. So, yeah, that third notice, notifying us before them notifying us before it goes there, notifying us before it goes to the taxes, that is definitely something that we will probably want to see. We probably will have some more conversation and get back to you about if there's anything else that we would like to see included in the legislation.
Yeah, and it's just an amendment to add in the local tax rollover component. So, the local legislation is really just a copy paste of the state law. And then you have it in the local law and the Syracuse Property Conservation Code as an ordinance. The only difference between the two is the SPCC has the fine and penalty schedule. So that's why you have two copies, and it was two separate letters, one for the law, one for the ordinance. They're verbatim the same. It's just has to be amended in both places.
Okay. All right. Okay. So
yeah, just let me
if
know
we have
anything
any
else we
further
can
discussion, I'll
provide.
definitely let you know. If not, then I'm not certain. Brian stepped out, so I don't think you don't have to change anything in the verbiage.
No, the verbiage, Ryan, that would be, Ryan's right there.
No,
Brian. The verbiage, no, because it would be that rollover, and then we would institute, Ryan could send the names and addresses of the legal warning letters, I'm assuming, have someone on his staff compile that, and on our end, again, it wouldn't be till we enacted it going forward, so you wouldn't get a list from us of any properties ripe for rollover until they've gone through the whole ticketing process, the default process, past that 30 days, and then at that point, you would get your first list of these are ripe for rollover come, again, May of 2026.
Okay.
And then we could always follow up once we have a final poll of that list, January of 26 or something.
Okay.
But it's obviously going to take a while before we get to that point.
Okay, all right, so thank you. I do appreciate you guys coming and informing us on this. And thank you to the counselors who did attend and for all your feedback.
Thank you.
All right, call this meeting adjourned.
Jimmy took care of one. That was. Yeah, I know it was one that. Bradley place or something. Yeah, it was actually two houses that you guys held because, and they didn't violate it because of that. But I know one of them was, and Jimmy ended up talking. This is the last one. Jeff Dennis. He did. I know, I think it was one that Jimmy did.
So I just want to, because I just talked to this lady on Friday, this little old lady that, her age, she was in that area. But it wasn't red.
That's a place of
What is, that one? I don't know if Mike's still out. I don't like to.
I was just going to ask you, you said you had, I've never seen you reach out on text trust. Was it that you needed help with?